And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that we'll address second. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend that the voicemail left on Mr. Lally's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, said essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want. And that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of 1 juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and this, again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and procedure is important. Form sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burdens being on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice, and it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matt v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleading, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8th? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement, it's called an appellate case, 485-90, said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, that the jurors accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, it's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate. Or, alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure the media would, but to keep this private and keep this confidential, because we don't want the jurors to, risk